Good afternoon and welcome back to the latest installment of Treasure Coast Business Disaster Relief Efforts, brought to you by the Virtual Business Recovery Center and the Corporate and Community Training Institute at Indian River State College. This webinar is sponsored by the Florida Small Business Development Center, hosted at IRSC, and the Economic Development Council of St. Lucie County. I encourage you to post any questions, suggestions, comments, or concerns in either the Q&A or chat area of this virtual meeting room. Both can be found on your Zoom taskbar. Today's topic of discussion, COVID-19 and the Fair Labor Standards Act by CCTI instructor Tom Epsky. Thank you for joining us today, Tom. I'll now turn it over to you.
Thank you very much. I appreciate the opportunity. Let me go ahead and get my screen going. There we go. All right. Well, good day, everybody, and welcome to today's webinar, hosted by the Virtual Business Recovery Center and partners, St. Lucie Economic Development Council, Indian River State College, and our local Small Business Development Center. I am Tom Epsky. I have the honor of serving the citizens of Florida as a commissioner on the Florida Reemployment Assistance Appeals Commission. The commission is a quasi-judicial tribunal that acts as an appellate court of appeal for contested reemployment cases that generally involve workplace misconduct, employee relations concerns, such as harassment and discrimination, or perhaps if an employer has made a unilateral and material change in the workplace. We also deal with issues surrounding today's topic, the Fair Labor Standards Act. The Corporate and Community Training Institute at Indian River State College offers training on HR and management topics like today's webinar. At the end of the webinar, I will share how to contact the college if you may be interested in further training for you or your staff. So the Fair Labor Standards Act is also sometimes referred to as the Wage and Hour Law. It is established, or was established in 1938, and generally talks about minimum wage, overtime, and youth employment, and some record-keeping standards that affect nearly all full and part-time workers in the private sector, as well as in federal, state, and local governments. It was designed to protect workers and address conditions that burdened the American economy during the Great Depression. And it's been amended over the decades, but substantially, we are dealing with a nearly 80-year-old law that is still trying to make sense in our modern 21st century economy. So let's talk about some of the core wage and hour regulations. The law had several purposes: to establish minimum wage for certain workers, to regulate the number of hours individuals must work before being entitled to overtime compensation, and to restrict the hours and conditions for employment of minors. And again, it was designed really to look at the protection of the economy during high period of unemployment during the Great Depression, to have employers want to hire more workers by assigning a premium at the rate of 1.5 times one's normal rate of pay if workers were employed over 40 hours in a work week. The hope of Congress at the time was to encourage employers to therefore hire more workers at straight time. So the first thing that one must do when considering the Wage and Hour Law, the Fair Labor Standards Act, is to think about who exactly are our workers. And this takes on a whole new significance during the COVID-19 global pandemic, because perhaps with reopening and other concerns that an employer may have to readjust their business model and strategies, they may take on some workers temporarily. One of the things to look at is that an employer has no ongoing obligation under the Fair Labor Standards Act to who we consider self-employed independent contractors. Therefore, it is critical that your organization clearly identify which of its workers are employees covered by the Fair Labor Standard Act regulations, and which are independent contractors not covered by FLSA regulations. The distinction between employees who receive generally a W-2 for tax reporting purposes and independent contractors who receive Form 1099 is not always philosophical or apparent. Titles, labels, job descriptions for particular workers are often misleading, and neither the W-2 nor the 1099 is considered definitive when determining a worker's classification. So what we have are some specific critical tests that can be made when understanding who our workers may be. The Internal Revenue Service, as well as the Department of Labor, helps employers by giving us some critical tests for independent contractors. And they generally center on the three tenets of behavioral control, financial control, and the permanency of the relationships of the parties. So we'll take a look at what this generally involves. The Internal Revenue Service has developed what's called the IRS 20-factor test, which looks at some key standards for determining the idea of behavioral, financial, and permanency of relationship. And as you can see, one of the things that is looked at is whether the individual's work is vital to the company's core business, the training that the individual receives to perform tasks in a specific way, and can the employer instruct the individual as to when and where and how the work is being performed. Generally, employee activities are an integrated part of the organization's business operation, whereas an independent contractors typically serve a more limited or non-essential business activity. Employees are usually taught the very specific way work procedures that are expected to be followed and must be complied with are done in the organization. Employees are held to the requirements with regard to these activities and generally work on a schedule determined by their employer, where independent contractors are generally considered experts in their field, and as such, their work methods are most appropriately determined by themselves. Additionally, they are typically held accountable only for the outcomes and not the manner in which they are achieved. Independent contractors can work whatever hours they choose, provided that there's an agreed upon deadline that are met in most cases. As far as hiring, independent contractors are usually free to do the tasks for which they were hired themselves, but can typically hire their own assistants and supervise and pay them, where employees must do the tasks for which they were hired themselves. Employees usually are expected to devote all of their working hours to their employer and are ordinarily required to work on site. They may be asked to provide status or activity reports on a regular basis and are usually paid at fixed intervals, where independent contractors generally work on a project-by-project basis, each time with a new contract. They don't spend so much time with any one company that they are restricted from doing projects for others, and in fact, generally work for multiple clients concurrently. Independent contractors are free to work off-site, such as in a home office, and they're responsible for producing a final deliverable outcome. and are not therefore required to generally provide those interim reports. Employees are generally furnished the tools and equipment and material, company provided supplies, if you will, where independent contractors generally are expected to use their own tools and supplies and resources. They incur the expenses related to workspace, equipment, etc., whereas employees typically use their company's facilities, tools, and equipment, and generally are reimbursed for expenses like for travel, etc. So these are some of the ways that the Internal Revenue Service and the Department of Labor may look at an independent contractor and the exercise of behavioral control, financial control, and the permanency of the relationship. Neither of all of these categories is demonstrative. For example, in terms of permanency of a relationship, many people may have, for example, a landscape company that they've utilized for their home for many, many years. Just because that ongoing relationship lasts a long time doesn't mean that if that check mark is more to the side of an employee, that suddenly you're going to have to start paying your landscape contractor as if they were a personal employee. It is more to the number of these tests, and the more favorable to an independent contractor, the less defensible an employer will have an argument to make that this person is legitimately not an employee, which then involves the taxes and insurance and overtime provisions, which we'll talk about. So under common law rules, anyone who performs services for you is your employee, basically if you can control what will be done and how it will be done. And this is so even when you give the employee freedom of action. What really matters is that you have the right to control the detail of how the services are performed. And again, we have this IRS Factor 20 analysis, which can help guide us on many of these. Now, once you determine that your workforce is an employee, the next step that we have in the evaluation is to determine whether that employee is an exempt or non-exempt employee. The exempt and non-exempt distinction is very important. Under the Fair Labor Standards Act, exempt employees are excluded from the minimum wage and overtime pay requirements of the law. Non-exempt employees are not excluded from minimum wage and are entitled to overtime pay. This figure shows the path employers follow to not only determine employment status, but then employee status. Now, this is kind of an interesting development in the Fair Labor Standards Act with some differences that were enacted in 2020, which I would like to cover. The exempt versus non-exempt. As you can see, in order to properly classify somebody as being excluded from the minimum wage and overtime requirements of the law, to be exempt, there are three prongs that an employee must have. And you can see them there. It's the primary duties test, the salary compensation, and the minimum salary. So the first thing that I would like to talk about is that minimum salary. The minimum salary is important because it was just raised in 2020. I'll talk about that in a moment, but just be aware that if you don't meet that prong, it really doesn't matter about the primary duties and the salary compensation. If these three prongs are not met, then your employee must be considered a non-exempt employee. That means that they are excluded from the ability to exempt them from the entitlement to overtime, and you must pay them if they work, especially over 40 hours, time and a half. And so we'll talk about these white collar for exemptions and blue collar non-exempt employees. So under the exempt categories, we generally hear classifications such as executive, administrative, learned professionals, outside sales. Exempt employees have to work in a bona fide manner in, for example, these executive, administrative, professional, and outside sales positions. The issue of primary duties is an important part of the exemption. So as an employer, one must really understand what a primary duty is. And that is the main or most important duty of the position. To be exempt, an employee's primary duty must be the performance of exempt work. And while the IRS or the Department of Labor doesn't necessarily assign a particular percentage of exempt duties as required under the Fair Labor Standards Act, the lower the total percentage of exempt duties, the greater the legal risk to the employer is if challenged by the Department of Labor. Conversely, if more than 50% of time is spent performing exempt work, the employee is more likely to be considered exempt. However, again, there is no 50% requirement under federal law. The DOL, the Department of Labor, has issued various regulations on the Fair Labor Standards Act, white-collar exemptions, and have looked at the qualification. Essentially, if you're not meeting these requirements, again, paying a minimum salary, paying on a salary basis. Oftentimes, employers run afoul of the Department of Labor regulations when, for example, they classify somebody as exempt, say that person has exhausted all sick and vacation leave, and they work a part of the day and become ill and have to go home, and then they start docking their pay or somehow assigning an hourly equivalent to the work that an exempt level person is doing. That could be problematic because exempt level white-collar professionals are deemed to be paid to perform a job, regardless of the number of hours that that person would be expected to finish. And so we have to look at those in a very specific manner. As far as non-exempt, those blue-collar workers and other status, blue-collar workers are defined by the Department of Labor as those who perform work involving what is called repetitive operations with their hands or physical skill and energy. And the Department of Labor has stated that individuals in these positions will not be exempt no matter how highly compensated they are. Oftentimes, we see professions such as carpenters, construction, plumbers, and others in a very highly straightforward, using their hand type of operations as being considered blue collar. So again, let me go back to that minimum salary because this is an important distinction. It was $455 a week or $26,660 annually as of January 1st of this year. Now, in order to be considered exempt, an employee has to make a minimum yearly salary of $35,568. That equates to about $684 per week. So therefore, if your employee does not meet that minimum salary threshold right now, they cannot be considered as a white-collar exemption under the FLSA. So if you previously had an employee that was above the old threshold of $26,660 annually, but now doesn't meet that $35,568 annual salary, as an employer, you have a choice. You can either reclassify them as non-exempt, but track their hours very carefully to make sure that overtime wouldn't be necessarily having to be given, or you can raise their salary in order to keep them exempt. The highly compensated professional threshold was also changed to now have $107,432. Part of the problem through the years, the last adjustment was made in the mid-1980s, Fast forward 35 some odd years, and our wages went out with, cost of living and inflationary trends. So in readjusting these numbers, the Department of Labor kept into consideration some contemporary type of salary numbers. However, interestingly, when they passed the final rules regarding minimum salary, they did not build in any ongoing updates in terms of review, but they said that they would do more frequent or periodic updates to these minimum salary tests. Okay, minimum wage is also part of the Fair Labor Standards Act. With COVID-19, maybe employers are looking to hire some folks, at a minimum salary, again, just to help them and get them back open, or to be able to do some work, maybe hiring people to change the business model somehow. We all know that federal law is $7.25 an hour. However, that is, while enumerated under the Fair Labor Standards Act and the federal law, states can and often do enact higher minimum wages. And in fact, the state of Florida has its own minimum wage law passed by a constitutional amendment a few years ago. It's readjusted every year. So as of January 1, 2020, the Florida minimum wage is $8.56 an hour. For tipped employees, that equates to $5.54. So regardless of what we see for the federal minimum, all employees in the state of Florida have to make, unless they're a tipped employee, the $8.56. So little test here. Doesn't matter what the federal minimum wage is. If your state minimum wage is higher, that's what you're required to pay as an employer. It's always more favorable to the employee. Now, one of the things I wanted to mention is a potential change to this minimum wage law in Florida. In November, the electors will go to the polls, and one of the questions that they will be asked under the constitutional amendment section is Amendment 2. The Amendment 2 proposal is to raise Florida's minimum wage to $15 an hour. It's called the $15 Minimum Wage Initiative. A yes vote on that amendment supports the initiative to increasing the state's minimum wage. A no vote would oppose the initiative and leave the state's minimum wage according to the previous constitutional amendment. It would be a phased-in type of process, beginning with a $10 minimum wage on September 30th, 2021, and increase $1 each year until September 30th, 2026, where we would reach the $15. Now, in 2004, when we passed that state minimum wage amendment, which is indexed to inflation currently, that amendment passed 71% to 28%. In Florida, we need a 60% threshold of the electors to approve a constitutional amendment. So this could have a lot of effect on especially small business in Florida if this amendment passes, because that would require us to have that phased in up to a $15 minimum wage. And we can see here that as of this year, many states have different minimum wages. There's a lot of talk about the $15 minimum wage in certain cities like New York and Seattle, California. But we can see here that many states have initiatives above and beyond the Federal Fair Labor Standards Act. And Florida is included with that, with its current indexed to inflation constitutional amendment. Now, another provision in the Fair Labor Standards Act is overtime. Overtime pay provisions for non-exempt employees state that any worker who is non-exempt has to be paid a premium, which is called overtime, at a rate of 1.5 times their regular rate of pay for hours worked in excess of 40 in any work week. Now, the regular rate of pay is anything that includes their base pay, and it also includes non-discretionary bonuses. Those are bonuses that are tied to performance, the quality, the quantity of work. It also includes shift premiums, production bonuses, and other commissions. So all of those have to be factored. So if you have an employee that may make $10 an hour, but yet also receives a shift bonus or a non-discretionary bonus because they were able to produce a certain number of elements in a manufacturing environment, for example. All of that has to be added together to come up with the proper base period pay. What's not considered in that would be a discretionary bonus. So these are typically bonuses that are paid to an employee, say like at holidays or on special occasions, generally $25 or under, or, not tied to any specific bonus or benefit of the employer, like options due to certain financial incentives. Now, one of the things that an employer needs to understand is that under the FLSA, a work week is defined. So there's some flexibility there. A work week is simply any fixed, recurring 168 consecutive hour period. 168 hours is what we have in 7 days at 24 hours each. Doesn't matter when your work week begins. Some employers may decide to begin a work week on a Monday or a Wednesday, some on a Sunday. But the caveat is that you must keep that consistent for any class of worker, over time. You shouldn't have different standards. So 1 week it's going to start on a Sunday, 1 week you're going to shift it to a Tuesday, the following week it's going to be back on Monday to avoid paying overtime. So keep it consistent. You can, however, have different work weeks for different sites or different classifications of employees as long as it's consistent over time. So just for kind of a quick review, you can see we have a generic calendar here. This employer decides that their work week is starting on a Sunday and ends on a Saturday for that class or that particular location. Absolutely all right. Same thing goes for an employer that may want to have a Monday to Sunday schedule or a Thursday to Wednesday schedule. But let's see how this works out in practicality. So this employer pays on a biweekly basis. So as we can see here, in week 1, the employees worked 44 hours. They've worked a little bit of excess time on Wednesday and Thursday. Now in week 2, the employer says, oh my gosh, we are really on a tight financial, kind of footing here. We want to roll back a little bit on excess wages. So on Friday, we're going to send the worker home early and only have them work 4 hours. And since we pay on a biweekly basis, look, that averages out to 80 hours and therefore we wouldn't have to pay overtime, right? Well, the answer there is wrong. The Fair Labor Standards Act defines the work week. So in this example, the employer is still obligated to pay 4 hours of overtime, that is at 1.5 times the normal rate of pay for week 1, and then you could pay the 36 hours of straight time in week 2. Now, overtime is only on hours worked, not on hours paid. So in the current example that you see here, we have the employer closed on Memorial Day, but nevertheless, they pay their employees holiday pay. Well, in this first week here, the employees worked 36 hours, but has received 8 hours of holiday pay. Now, while that's also over the 40 hours in terms of the number of hours they're being paid, in this case, no overtime is required. The next example we can see similarly. We have a little bit of extra hours on Thursday, but because the holiday and Tuesday was a sick pay, even though it's going over the 40 in week 1, you would have no overtime obligation. However, to make up for maybe while the employee was out the week before, in this example, the employees worked 12 hours on Monday, Tuesday, Wednesday, and 8 on Thursday, Friday. In the second week here, you can see the employees worked 52 hours. In that example, then for week 2, that employee would be entitled to 12 hours at a rate of 1.5 times. So no overtime needs to be paid on sick pay, holiday pay, vacation pay, even jury duty pay, or similar unworked days. It's only required to be paid on time work, not on time compensated. Now, this is very important, especially with folks working from home during the global pandemic, teleworkers or remote work. It's the obligation of an employer to keep very accurate time records. I will tell you that South Florida has generally led the entire United States in claims of wage and hour violations. The Wage and Hour Division is very active here in South Florida investigating employers. And one of the first things that they will look at, especially if it's related to misclassification of employment or overtime, is they will examine the weekly time records. So as an employer, please make sure that you are having your employees keep very accurate time records. One of the things that raises a red flag right away is when you see somebody, across the board, week after week, putting down that they start at 9 and they end at 5. Have employees receive training on being very specific. 9:05, 9:07, 5:02, 5:05, to be able to provide a record that they are accurately reporting, especially if this is on those self-reporting timesheets and not on an electronic time system. And we're seeing more and more of these types of issues when people are working from home, for example, and may not have access to an online electronic system to log in when they're working. So very important that we keep accurate records. Question that I'm asked a lot is on meals and breaks. What am I required to do as an employer in terms of furnishing breaks? And a lot of people are surprised to hear the answer that under federal law, there is no requirement for employers to provide a meal or rest break to employees. So sometimes we have states that have enacted more stringent benefits. Florida is not one of them. So as an employer in Florida, now from a human resource background, I will tell you I don't advise having your employees work 8, 9, 10 hours a day without a break or a rest period. Number one, I think productivity long time suffers. People need that little bit of disconnect from the work, but also from an employer of choice, being marketable to want people and talented individuals to apply and stay with you. It's just good practice to allow people to take breaks. But technically speaking, under the law in Florida and on the federal basis, you have no requirement to do so. Now, rest breaks that last 20 minutes or less, however, under federal law have to be paid. So if you're going to offer an employee, let's say a 10, 15, 20-minute break in the morning and afternoon, those are always compensated. It is only when you have a meal break of over 30 minutes that you do not have to compensate an individual as work time. Now, I've oftentimes tried to figure out where is that, gray area between 20 and 30 minutes. I don't know. Nobody's been able to effectively answer that for me, but I will tell you that in order to not pay an individual, anything less than 30 minutes is my standard. So if you're going to allow somebody to take a lunch and not wanting to compensate them, ensure that it's 30 minutes or more. Anything under that should generally be compensated. And that's why I think employees are usually given a 15 or 20-minute break, just so it doesn't go over consistently. Somebody that says, well, I was off the clock for 29 minutes, but maybe it was 30, therefore, is it going to be paid or not? And I think that's why you see those standards as they are. One of the things, as I mentioned, that has been done through the years is kind of expanding, when issues arise, the idea of the Fair Labor Standards Act and certain provisions. And in 1947, Congress passed the Portal to Portal Act that amended the FLSA, and it defined additional rules for what we must consider hours worked. The Portal to Portal Act helps us to understand when the actual workday begins and ends. And generally, this is looked upon with regard to employer restrictions. If an employer restricts an employee's activities and does not allow any personal business, then the hours are included as time worked, including in overtime. So employers may not be required to pay wages or overtime when an employee, let's say, is off the premises and on call. Let's say they're asked to stay by the phone or computer, or carry a mobile device and respond to a pager, as long as the employee is generally not otherwise restricted. However, we see, for example, let's say a hospital has a radiology technician who is on call for nights and weekends, and they must respond within 20 minutes of receiving a page or call to come into work. They must come in scrubs or other types of protective gear. When the more as an employer we restrict the idea of an employee's time, even off premises and away from work when they're on call, that may be where we have to now start paying them. The Portal to Portal Act also looks at other provisions, such as when work would begin if we're in a company vehicle. So for example, if I'm a worker, let's say a plumber, and I come home with the company vehicle and there's tools and plumbing equipment in the van, and I start my workday by getting in the company vehicle and driving to the office to get my assignments and clock in and then start going to customers' houses, that commuting time is generally not considered work time. It's commute, like most people would have a commuting time, which is not compensated. However, if the company requires an employee to call in and say, okay, your first job is going to be at 123 Main Street, and I get in my van in my driveway and I go right to the customer's premises, well, then I'm on the job. So that time spent in the van from the time it leaves my driveway to the customer's house would be considered compensable time. So we have to look at travel, especially in work vehicles, when the workday begins. So we talk about work travel. If we're traveling in the course of a workday from one work location to another, that's an employee that's entitled to compensation for their travel time. Travel to work-related meetings is also compensable. We know that out-of-town travel during the course of a day could be compensable. It may not be. It just depends. For example, an employee who may travel from home overnight and is not working when he or she is a passenger in, let's say, a train or an airplane, a bus, or in a car. However, when that time that the employee spends traveling as a passenger is on a weekend, it would be counted as work if the travel cuts across the hours that the employee would normally work. Also, any time that an employee spends working while a passenger must be counted as paid time off. So this is something that you'll want to track very carefully, the activity and when the travel may be compensable, especially by custom or practice, as opposed to generally commuting time, especially where as an employer, attendance to these offsite or out-of-town meetings or conferences is mandatory and is job related. So you want to look at those provisions especially well. Preparatory and concluding activities. So I may have a uniform that I'm required to work at, and I'm changing at home and coming to work. Generally, that is not compensable. But there are some positions, for example, let's say I work for Apple, and I'm assembling, the new iPhone, and I have to wear a special suit to keep down dust and other contaminants from getting into the components, and I can only do that at work. Well, even though I may not be at my workstation, but I'm in kind of an ante room, donning or duffing activities, the putting on or taking off of specialized clothing, that's been defined as compensable time, the donning and doffing, especially of specialized suits. So we deal with those types of issues too under the Portal to Portal Act. Generally waiting time. So I'm an employee, I come in and I'm sitting at my workday and I'm casually reading a newspaper or, checking my iPhone for, social media. Just because I'm at my workstation waiting for my work schedule to begin, that's generally not compensable. But if I sit down on my workstation and, I maybe earlier than defined starting time, but I'm starting to check emails and respond to customer complaints or respond to questions, that's where the clock would have to start running. If I'm at work and I've clocked in and, work for some reason is not ready because of an equipment breakdown, generally that may be compensable as well. One of the things that we have to just briefly talk about in light of COVID-19 also and paying employees is the Families First Coronavirus Response Act and the paid leave requirements. So while this may not be related to the Fair Labor Standards Act, the Wage and Hour Division is dealing with these types of laws, administration, and enforcement. And so this law is in effect through December 31st, 2020, and essentially says that as an employer, I have to provide up to 2 weeks, up to 80 hours of paid sick leave. So this is an expansion on even FMLA, the Family Medical Leave Act requirements. And it's up to 2 weeks, 80 hours of paid sick leave at the employee's regular rate of pay if the employee is unable to work because the employee is quarantined, say due to a federal, state, or local government order, or the advice of a healthcare provider, or that they are experiencing COVID-19 symptoms and seeking medical diagnosis. The law also says that as an employer, we have to pay up to 2 weeks, up to 80 hours of paid sick leave at 2/3 the employee's regular rate of pay if the employee is unable to work because of the need to care for an individual who is subject to quarantine. Again, pursuant to federal, state, or local government or health agency or a healthcare provider act. Or if we're caring for a child under 18 whose school or childcare provider is closed or unavailable for reasons related to that. Covered employer must also provide to employees that it has employed for at least 30 days an additional 10 weeks of paid expanded family medical leave at 2/3 the employee's regular rate of pay, where an employee is unable to work due to a bona fide need to care for a child whose school or childcare provider is closed. Now, one of the provisions here is the employer notice. Please make sure your site and your facility has, as part of the required employment posters, the ones that we see, it's the law that generally deals with discrimination and harassment and wage and hour, that you also have the poster on your premises with notices of the Families First Coronavirus Response Act, and that you don't take any retaliatory action. Some of the things that's expressly prohibited under the FFCRA is that as an employer, you may not discharge, discipline, or otherwise discriminate against an employee who takes paid sick leave under the Act's provisions, or if they file a complaint or initiates a proceeding under that. And the paid sick leave and expanded Family Medical Leave Act provisions of the FFCRA apply to employers who have fewer than 500 employees. So the only maybe exemption is for very small businesses with fewer than 50 employees who may qualify for an exemption from the law's requirements. And that's only the requirement to provide leave due to school closings or childcare unavailability. But it's only for key employees whose absence would jeopardize the what the law calls the viability of the business as an ongoing concern. So you definitely want to check with your legal or HR representative to make sure that you're doing things correctly on that. Another amendment to the Fair Labor Standards Act is the Equal Pay Act of 1963. And Congress recognized that there may have been a disparity in how employers paid women and men, and therefore said that sex-based discrimination in terms of wages is illegal, and put into place the Equal Pay for Equal Work Act. Congress and the courts, in evaluating that law that Congress passed, generally look at a job with the same skills and efforts and responsibilities performed under similar working conditions as comparable work. So when we talk about equal work, jobs do not necessarily have to be identical, only substantially equal. And that's where we look at the skill and effort and responsibility. And it doesn't mean that you have to intentionally want to discriminate. So intent is not part of the equation. And just quickly, I remember a case several years ago where we had a valet service working down in South Florida. The company hired mostly guys at the time to be the valets that would park the cars and have to run back to the curb, go out to where the cars were parked and retrieve them for a customer. And at the desk with a fan and undercover, they hired a lot of women to be kind of the reception person, to receive the keys or the claim check and make sure the valet got that properly and collected any monies that were necessary. And they determined that because the men that were actual valets running out in the hot elements or the rain or the adverse conditions that sometimes ensue in South Florida, that they were going to pay the guys a couple more dollars an hour for that because the women were kind of in the comfort of the booth with a fan and not having to be out in the hot direct sun and heat all the time. Well, the court looked at the substantially equal clause and found that that was a violation of the Equal Pay Act because, you know, when you look at the jobs, even though they clearly weren't identical, they were substantially equal in the court's eye. So those are some of the ways that a court will generally look at this. Now, I'm not saying that as an employer you have to be worried if you have differences in pay. The differences in pay between men and women just have to be on factors other than sex. So anything that fairly measures, let's say, seniority. Public school teachers are a good example of this. You may have Mr. Jones teaching 5th grade that makes a couple of thousand more than Miss Smith also teaching 5th grade in the exact same school in the classroom next door. But Miss Smith is a fairly new teacher, only working in the district for 2 years, where Mr. Jones is a 15-year employee and through step increases and cost of living is making more. That's clearly based on seniority and longevity. And maybe merit with advanced degrees or certification, as long as it's not sex-based. And this becomes important because in 2009, the Congress passed the Lilly Ledbetter Act, which overturned a Supreme Court decision, Ledbetter versus Goodyear Tire and Rubber. This was a Supreme Court case decided in 2007, where the court ruled against the petitioner, Lilly Ledbetter, and her claim of sex discrimination in pay under Title VII. And the court ruled that Ledbetter's claims were not timely because she didn't file discrimination charges with the EEOC within the mandated 180-day timeframe, which is a prerequisite for bringing a discrimination suit. And Congress overturned that and said that the statute of limitation resets the employer issues each allegedly time that a discriminatory paycheck is issued. So the open-ended nature of the law's coverage of unlawful employment practices, which includes compensation decisions, suggests that employees and even their families or heirs could file discrimination lawsuits against an employer regarding benefits every time a paycheck has been issued, and renewing that 180-day statute. So something to keep in mind for employers. All right. Well, that was just some of the highlights, especially in our new world consideration with COVID. I would like at this time to be able to open it up to some questions. The bottom of your screen, you have the Q&A feature there, or the chat feature. If anybody wanted to ask a question, you can go ahead and do those now, and I'll be happy to try to entertain those. In the meantime, if you have any further follow-up or you can think of any questions, here's some of the links for the EDC and the Virtual Business Recovery Center, which is sponsoring our webinar today. You can reach them at https://yourudc.com. The Corporate and Community Training Institute, which provides training opportunities to small business, and the Florida Small Business Development Center at Indian River State College can be reached at irscbiz.com or 772-336-6285. And of course, I can be reached at my college email, which is tiepsky@irsc.edu. So we do have a question on the youth employment and what kind of restrictions that we generally see in youth restrictions. Well, it's important for us to understand that the Fair Labor Standards Act does restrict the hours and conditions of employment for minors and protects children under 18 years of age from what the Act defines as oppressive employment conditions. So as an employer, I would recommend that you obtain an employment or age certificate that's approved by the Wage and Hour Division, or maybe issued by an appropriate state agency or the minor school. Child labor provisions under the Fair Labor Standards Act are designed to protect educational opportunities of youth and prohibits their employment in jobs that may be detrimental to their health or physical or mental safety in general. So that type of evaluation standard is something an employer should keep in mind. And it also restricts the hours that a minor can work and lists those hazardous occupations that are too dangerous for younger workers to perform. Any other questions? All right. Well, I'd like to thank you for your attendance today and discussing the kind of the key areas that the wage and hour law needs to be looked at in light of some of the new 2020 provisions, like for minimum salary, and also in COVID-19, and that sometimes we're taking on these very temporary workers that may still have to be considered employees and under the obligation of taxing and benefit schemes that are required by statute. So please pay attention to those. And again, I wish just everybody luck and success in operating their business as always. Katie, I'll throw it back to you.
Thank you, Tom. We greatly appreciate you taking time out to give us this great presentation. And thank you everyone for joining us today. Tune in again on Wednesday, July 8th at 10 a.m. We're going to be answering your questions on using Google Maps for marketing that you are open to the communities that you are serving. You can register for that in advance or view past webinars by going to youredc.com/VBRC. Again, that's youredc.com/VBRC/. Thank you, everyone, and stay safe.